Hello, ladies and gentlemen. I am Professor Paul Carrier of the Western Michigan University Thomas M. Cooley Law School. What I'd like to do now is to provide some information with regard to Class 7 of Contracts 2. And to do that, though, I need to mention briefly where we are, where we've been. Last week, you took the midterm examination, which dealt primarily with either an issue of integration for one of the classes or interpretation for the other of the classes. After that, we somewhat slowly began the process of studying third-party beneficiary law. So slowly, in fact, that what used to be one class period of material on third-party beneficiary law, I have decided to spin out into basically a class and a half. So we started third-party beneficiary law last week after the midterm, and we are continuing today, this week, Class 7, so that we've had time to consider what's going on. A major empowering experience is understanding when you see a fact pattern, when and whether to lead off as your primary issue on third-party beneficiary rules, contrasted to, for example, something else like conditions, or, as we learned from next week, week 8, on assignment and delegation. And as simple as this may seem, forgive me if this is a little bit simplistic, but I want to explain again one more time so that you understand clearly in your minds what's really going on. When you have, let's say, it could be more parties, but you have two parties, and those two parties are making a contract, promise for promise. But in that set of negotiations, a third party is being considered, directly or indirectly. For example, I will buy the car from that auto dealer for you. You've got buyer, you've got recipient, and you've got auto dealer. Okay, whether that's incidental or intended is a different question. But you see the three parties up front. That's the key. Or, I want you to take my money and when I die, give the life insurance proceeds to my family. You see, in the deal, when you're making that contract, there is contemplation of a third party. That is when you use third-party beneficiary law to determine whether or not that third party now has the right to legally enforce what he or she expects to receive based on an agreement where he or she had absolutely no privity of contract. And let's see here. I'll come back to that in just a second. Let's change that. And this is where I want you to change your mindset for the week 8 materials on assignment and delegation. Let's presume that there are two parties to a contract and there is no contemplation of any third party. I promise to buy your bicycle for $100. I promise the $100, you promise me the bike. That's it. Subsequent to that formation of a contract, one of us decides to make some change involving a third party. You want the money not to go to you, but to your brother because you owe him some money. Or I want the bicycle, once payment is made, not to go to me, but to my neighbor. Who knows? Do you see that after the first contract has been formed, now there's a subsequent brand new contract, basically, an agreement between me and you, involving a third party. That is when you deal with assignment and delegation law, and you lead with that. So you see a post-contractual assignment or delegation go into assignment and or delegation law. If you see something like that involved in the original contract, the original dealings, then you go with third-party beneficiary law. And not to confuse, but let's say you have one contract. I buy your bicycle. I promise to buy your bike. You promise to sell me the bike. Okay. Later, you and I talk and I say, please, would you give the bike to my neighbor? Isn't that an agreement? That second agreement of not getting it to me, but giving it to my neighbor? That would be the assignment of my rights to the bike, assigning them to another party. Okay? It is a second contract. But that separate contract now, between me and you about where it goes, that involves that third party. Again, it's a second contract, but it's me and you, and now it's a third party. And so if you see some interchange or some interconnectivity between third-party beneficiary rules and assignment and delegation rules, The reason is because when you have assignments and delegations, that is when you are in fact bringing in a third party, and third party beneficiary rules are relevant. To stay focused, however, I recommend that you always work with the idea. Let's look at which contract I'm considering. Is there a third party contemplated within it or not? The answer is yes, third party beneficiary law. If the answer is no, then you have a regular contractual aspect. Okay, you have a buyer-seller, possible breach, performance, etc. If there is a contemplation of a third party, then you have other questions to answer. For example, is it a creditor beneficiary, donee beneficiary? I'll explain a little bit more on that in just a minute. And where there is an agreement with no third-party beneficiary implications, but later there are third-party implications. Now I want to assign my rights. Now I want to delegate my duties under the previous contract. Now you've got an assignment delegation system, and you ask some different questions when you're dealing with assignment and delegation. So again, they are interconnected, but if you very carefully up front define whether it starts as a third-party beneficiary question or whether it starts as an assignment delegation question, and treat them respectively differently, it will help prevent significant confusion. Okay, so third-party beneficiary rules. Last time, remember, with third-party beneficiary rules, the problem has always been at common law there would be a lack of privity. If a contract contemplates the benefit or activity of a third party, that third party was not there to discuss. That third party was not there to sign a contract or shake hands. And so there would be no privity of contract between that third party and any of the two parties to the original contract. And at common law, that meant that that party without privity did not have any legal rights that could be asserted in court. It was possible off the record in the old days for a court, in the case of unfairness, to apply equity and create, for example, a constructive trust. Well, that person doesn't have privity, but you basically set it out so that he thought he had a right, and he began to act to his detriment on that right, and it wasn't his fault to believe that you were going to do this based on your contract. And so in equity, we must let him step in and get benefit, because otherwise he relied on his detriment or to his detriment on something that you led him to believe was valid. So constructive trust equity could have handled the situation. Privity of contract, though, was not there, and so the courts of law would not hear those cases. Over time, we see a gradual easing of the rules. There's the no privity, no rights in a third-party beneficiary rule. That's the original rule. And we begin to see some exceptions to that rule in appropriate cases. The first one being the creditor-beneficiary scenario, where two parties make an agreement and the agreement is going to remove the debt of one of the parties that a third party holds. Why not? Cut through the middleman. Just let that first guy stop being a debtor with a creditor, deliver the money. That was the Lawrence v. Fox case. Okay? Next case we learned, and Ransom v. Seaver has a lot of information in it, or Seaver versus Ransom. Another example would be where there's a family relation. I promise my dying wife that I will give my estate to her niece, something like that. Well, there's no privity with the niece. In fact, that's basically gift law, wouldn't you say? Not so much contract law. But if we shook hands or we signed, sometimes courts would say, let's let the niece have the right to sue. We will use this intended third-party beneficiary law as we begin to relax the privity requirement. And we will allow in cases like that third party to file a lawsuit and collect, even though there was a privity problem. Municipal contracts are a little bit trickier. If the city buys water pressure, a system of water pressure, and it doesn't work, can somebody whose building burned down sue? Initially, there was a point where the law was ready to recognize citizens and taxpayers as intended third-party beneficiaries of municipal contracts. Remember, it's the contractor and the city or the municipality signing the deal. Okay? are the intended beneficiaries the taxpayers or not? And whereas originally certain courts would allow that and allow the citizens to get around that privity requirement and sue legally in court, there are other public policy reasons now where it appears that most, if not all, jurisdictions have backed away from that. And so now if you see a municipality and a contractor, and then you see a third-party taxpayer trying to assert legal rights, don't bite on that one. And you can argue at best that party is an incidental beneficiary, never directly intended to benefit by that original contract. And therefore that third party, that taxpayer, would have to find recompense from some other source, but not based on contract against the contractor. Okay? Of course, then, in a way, kind of like the creditor-beneficiary scenario, there's a more generic or more open category, which is where two parties agree with a specific intention that the third party benefits. A life insurance contract is a perfect example. I buy life insurance company takes the proceeds, they're never going to give me anything, right? The plan is, at such time as I die, or untimely die, that money will go to these third parties. And we built that agreement up front with the third party benefit in mind. And so that is one of the classic examples of an intended third party beneficiary. Okay? With regard to Class 7, we are considering a few extra extensions or limits on whether or not we allow third parties to sue original contracting parties with whom they do not have contractual privity. And the first example is Blair. Government hires a private company to run the jail, and obviously it is a municipality, okay? And so you'd think, well, third-party beneficiaries don't have rights. That's what you just said, Professor. And that was from the previous week and the Rensselaer water case. But that's not to say it's not impossible for courts to change their minds. In this case, private company contracted with a government institution to run a jail. Question is, in that contract between contractor and government, did the contractor promise to provide specific benefit to the inmates or not? And the court in that particular case found that that contract did in fact have intended beneficiaries as inmates. So the inmates were able to sue directly the contractor. Interesting, in fact, it was a contractor, but I think it was a federal versus state issue. So the federal government let the state take federal prisoners. State says we have sovereign immunity. The feds said, no. These prisoners were given to you not under state authority, but federal authority. And you promised us you were going to take good care of it. And since you did not, you violated their rights. And we gave it to you intending for them to benefit from your expertise and your protection. You failed. They can sue you. Had they been state prisoners, maybe no lawsuit. But since they were prisoners brought in based on a contract between the federal and state systems, then it's as if the state had promised the federal system that it would take good care of these inmates, and there was intended beneficiary status of these inmates. Well, maybe it's politics. The feds didn't want to pay for it, so the state had to. Okay. Second case was the Bain versus Gillespie. A referee at a pro sports game or at a college hoops game, as examples, may have duties and responsibilities with regard to the NFL or the NCAA and the colleges they deal with, but fans in the stands are not intended third-party beneficiaries. At best, they are incidental. So that's a case where trying to extend third-party beneficiary rights to these incidental beneficiaries at best would go too far. There are quite a few examples in the materials for this week, so you may want to go over those and get a sense of what you think does count and what does not count with regard to allowing a party to get around the lack of privity and assert third-party beneficiary rights against some contractual party. Thank you.